For latest updates, subscribe to our channel and press the bell icon.
Hello everyone, my name is Viren Dayal and I'm going to talk to you about the details of various allied laws. In the preamble which I have shared, you would have seen that the custom officers, one of the function besides collecting of revenue is also to enforce various other laws of the country. So today I am going to begin with the very first border protection law or the allied law known as intellectual property rights or the IPR law. The government in the year 2007 introduced the Intellectual Property Right Enforcement Rules 2007 and categorized 5 kinds of intellectual properties such as designs, copyrights, trademarks, geographical indications, and patents. All the right holders, as an example, various brands, the shoes brands and other brands which you are aware of, are registered intellectual property right holders in India. And if any infringement or any counterfeit goods are imported by any importer in India, then the Indian Customs Department, the Risk Management Division of the Indian Customs, takes action, and what follows is the procedure for confiscating these goods. So let me first begin how this is actually done, how are IPR registered. So under the rules which have been framed, every right holder has to give notice under the rules to the jurisdictional commissioner of customs or the principal commissioner of customs that they are the right holders and they wish to protect their rights and therefore they want to be registered under the IPR laws of India. In the process of ease of doing business, the right holder who needs to be registered can directly apply in the Indian Customs Common Portal, what is known as IceGate, by paying the fees online of rupees 2000 and provisionally seek registration, and accordingly a lot of documents have to be submitted, a bond has to be submitted, then later on another surety bond has to be submitted by the proposed right holder. The bonds are of 2 types. One of the bonds is that in case the goods are counterfeit goods and various charges accrue, such as damage charges, detention charges, other charges will accrue, that has to be borne by the right holder. And another bond has to be given by the right holder, indemnifying the custom officers in case inadvertently any goods are not detected as counterfeit goods and they are removed in the common channels of trade and commerce in the Indian customs. Besides that, the bond also indemnifies all custom officers for whatever action they take under the Customs Act. So on submitting the centralized bond, PC or the CC, that is the Principal Commissioner or the Commissioner of Customs accepting the bond, a permanent unique identification number is assigned to that particular IPR, and the normal validity of the IPR is 1 year. Unless the IPR holder wants it for a lesser period, then he has to ask for a lesser period. Also importantly, the IPR holder has to inform Indian Customs whether the IPR is still in force or the period of IPR is suspended or maybe it is no more valid. In such cases, the Indian Customs must be immediately informed. So these are the conditions of the bonds, and once the bond has been registered, the RMD division will trigger all the customs formation in pan India, and should a counterfeit goods come into any part of India, AC and DC will get a warning by which it will on its own, suo motu, suspend the clearance of the suspected infringement of that particular copyright or trademark or patent of that particular right holder. What happens next? As per process, the right holder has to participate in the proceedings as per the timelines given and can also share information with the customs that why this should be a counterfeit goods. And similarly, the importer also will be asked how the goods have been brought into India and so on. Finally, when the goods are found to be counterfeit, then section 111D is invoked, which leads to the seizure of the goods which are liable to confiscation, because now the goods are found to be counterfeit goods and they are now prohibited under the provision of section 11 subsection 2. So the importer of the counterfeit goods will face the necessary civil liability and maybe the criminal liability as defined in chapter 13, 14 and 16 of the Customs Act, and the suspension of the goods, clearance of the goods will continue to be operational. What happens to the goods under the IPR rules is noteworthy to note. First of all, the infringed goods have to be sold or disposed of outside the normal channels of trade and commerce. That means it cannot be sold at all and it has to be destroyed or disposed of in that manner. And if they have to be re-exported with the permission of the right holder, then they have to go in an altered state. It cannot be exported in the unaltered state. As an example, let us presume that a container containing sports shoes are found to be counterfeit, and if the right holder gives permission that instead of destroying them, the importer wants to re-export them, then that can be done by Indian customs as long as they are exported in the altered form. That means they are cut into two pieces and only then they can be exported. So, in conclusion, the counterfeit goods under these laws are either destroyed or they are, if at all exported, they are exported in the altered state so that they never be reused again. So these are the features of the IPR laws which are currently in force under the Indian Customs Act, and the RMD, with the help of another software module prepared by them known as ARTS, ARTS, Automatic Recordation and Targeting System, helps nab pirated goods and counterfeit goods. I hope this information was useful to you. Thank you.
For detailed learning of all logistics subjects, visit www.logiveda.com.